I'd like to also pick up on another point that was touched upon by Mr. Burstein, and that is that the framework of the legislation speaks to, now in Section 60 of the Controlled Drugs and Substances Act, it used to be Section 22 of the Narcotic Control Act, it says that essentially the Cabinet can put a drug in the schedule or take a drug out of the schedule. And the only test is if they deem it to be in the public interest. Now, it appears, because I've hunted and hunted to try and find the ordering council that put cannabis into the schedule, there isn't one. And on all of the reenactments of the law, they've never used an ordering council to put cannabis into the schedule. So when they reenacted the Opium Narcotic Act in 1923, they just slid cannabis into the schedule. There was no considered debate by Parliament ever on this question. I think my friend quoted the issue, oh, honourable members, is a new drug in the schedule. That's all that was said. And so when they reenacted again in 1961 the Narcotic Control Act, same thing happened, never any debate. When they came up with the Controlled Drugs and Substances Act, again, same thing. So to suggest that there's been a considered debate by the elected officials on this issue, it simply hasn't occurred. They've always deferred off to a royal commission or a senate or a parliamentary committee. And all of those, once they've looked into it, have come back recommending that they head in the direction that the appellants are submitting that you should follow. And so then if you have regard to that test under now Section 60, this court in Morales and Pearson found that that criteria was vague, especially when coupled with the deprivation of liberty. So what we have, in terms of the framework of this legislation, is it's the Cabinet that decides whether to put a drug in the schedule or not, and they do it according to vague criteria. There's no meaningful, settled criteria as to the meaning of that term. And so there's nothing there that says you can only put a drug in the schedule if it causes harm to others or to society as a whole. It's simply if they deem it to be in the public interest. And the minute they put that drug in the schedule, it's an offense, and your liberty can be threatened. So my submission, that is another reason why you shouldn't be persuaded that deference to Parliament is what should occur here. Because Parliament's never really, in reality, decided this question.
Might be saying something about trafficking, where
sorry,
I don't see it in your fact. I don't see it anywhere.
In my factum, tried to restrict my position to possession only because that's what Mr. Caine was charged with, and I think Mr. Malmo-Levine pointed to the fact that I distanced myself a bit from the trafficking issue, saying all that we're concerned with in Caine is harm to the individual. But
I'm not faulting you. I understand, and that's why I asked Mr. Burstein the question. His client is charged with trafficking. Yours isn't. It seemed rather peculiar that you deal with trafficking. He not. But if you're not,
well, I'm prepared
you're
to.
Under no obligation to do so. I'm just curious.
No, I now support Mr. Malmo-Levine's position, even though it doesn't arise out of the Caine facts, because I think in my submission he's right. So long as the harm principle applies to the conduct, it's protected. So if a person possesses and uses marijuana and doesn't pose a risk of significant, serious, or substantial harm to others or society as a whole, that's protected conduct within Section 7. If the government wants to intrude, they go to Section 1 and try to do it. If the harms are not inherent, as he put it, if they are mitigatable or reducible, so he creates his harm reduction club. He puts up signs saying no immature youths, no pregnant women, no mentally ill. He had his members sign a pledge that they wouldn't drive or operate complex machinery or fly airplanes. He had them go through a safe smoking guide so that the particular thing that was identified in the evidence, smoking, not anything in the marijuana, incidentally, that the smoking, that they would use techniques to reduce the impact of the smoking. So it shows that voluntary regulation by an individual or a business or imposed by government is a way to reduce those harms to below the trivial. So that arguably, while Caine was involved in a black market situation, Mr. Malmo-Levine was involved in a self-regulated situation where the risk of harm was less than trivial.
Well, are you saying, and I may be dense, that it depends on the form of trafficking? That have a health store type of trafficking where you want the cannabis to be pure and so on and so forth, and that you instruct your members of the harm such as it is. That type of trafficking is different than the person lurking around the schoolyard attempting to introduce this somewhat harmful drug to school children.
Well, ideally, it would be better if there was government regulation so that everybody was required to follow the regulations that reduce the risk of harm. But yes, if the individual takes steps to reduce the risk of harm, then and if his or her conduct doesn't transgress the harm principle, then where is the government interest in interfering with it? If the conduct, on the other hand, does pose a risk of harm to others, then, in my submission, that's a different matter, and the government may be justified in interfering. I see my time is up, but I'm going to, if I may, because Mr. Burstein didn't get a chance to do it. I know Mr. Arve is going to touch on it. I'll just try to do it in a couple of sentences. The division of powers argument. Historically, in my understanding, health, while not enumerated in the British North America Act at the time, nevertheless was considered a provincial responsibility, and the only way that the federal government could legislate in relation to health was using the peace order and good government or criminal law power. And our submission is that in order to use those powers, there has to be a significant, serious, or substantial risk of harm. If it's not within the criminal law power, if you accept our submissions that the risk of harm here isn't sufficient to warrant the use of the criminal law power or any penal power, including the power under peace order and good government, we say then that it's unconstitutional in relation to the federal government, and it then falls on the provinces in the normal way as a matter of property and civil rights or local matters in the province. And so if you accept our submissions with respect to Section 7 and the harm issue, we submit that it's not within the constitutional jurisdiction of the federal government. The evidence in Caine from Dr. Peck, we particularly put this to him. When you, as the provincial health officer, go around and discuss health problems, does anybody suggest that there's a health problem in British Columbia from people using marijuana? No. When you meet with your counterparts across the country, do any of them suggest that there's a health problem nationally from marijuana? No. So it can't be said that there is some sort of national problem requiring a national dimension to legislate in this field, in my submission.
You're dealing with a regulated substance. If it was unregulated, maybe the answer would be different.
Well, we submit it shouldn't be regulated because it doesn't meet the threshold.
I know what you're submitting, but I don't see that the evidence that you quote saying there is no health problem.
Well, that was the evidence.
No, but the drug is regulated. If the drug was freely available, the answer might be different. It might be a health problem.
The evidence also dealt with the field studies in Jamaica, for example, where it's been used for ages. And
I know, and you legitimately quote the evidence that favors what you're saying, but in the record there is evidence that there's harm, some harm. And I'm saying simply to you that you can hardly say there is no health problem when you're dealing with a drug that's regulated. We don't know whether there'd be a health problem if it was unregulated.
Well, again, my answer to that would be there are examples of countries throughout the world where it is unregulated, and there doesn't appear, there's no evidence to suggest that they've got a major health problem arising from it. I grew up in Africa, and my father used to pull the marijuana plants up when he saw them and throw them on the ground as he was walking through the tobacco field. We know there's lots of harm from tobacco, but the Africans smoked dacha, as they called it, all the time, and I've been waiting since 1923, I think we've been waiting, and certainly over the last 40 years, or 30 years in terms of my practice, trying to find where is this particular problem from the marijuana use. Where can we see a manifestation of the problem?
I thought by identifying a number of situations where vulnerable people might need protection, yes, which has been a classic area where the criminal law has been used. It was identified, for example, and discussed at length in Rodriguez. Here we have vulnerability of mentally ill, pregnant women, youth, and so on, and you concede that. So it seems to me that while you make an overall argument of little harm, there is that vulnerable group at very least.
But we don't penalize everybody in order to protect the vulnerable group.
I don't know if that's the correct principle of law. If you read Rodriguez, I think you see that there seems to be a consensus that there can be general prohibitions if Parliament deems it useful, and if it, of course, they have to show some, based on the evidence. But there can be, you can impose general prohibitions, I think, in order to achieve the goal of protecting a vulnerable group from harm. As a matter of law, it seems to me.
Yes, but that's why I submit that we should be under Section 1, because then we could deal with that under Section 1. Is there a pressing and substantial need to override the Charter right? Is it rationally connected? Does it minimally impair? Does the good from the law outweigh the bad, or does the bad outweigh the good? And one can tailor then to protect vulnerable groups.
Yeah, that's right. So I guess the question is whether you get through Section 7 so you get to Section 1.
That's right. And before I sit down, if I can quickly just quote to you from R.G.R. MacDonald, again, why you shouldn't defer to Parliament. I'm quoting from paragraph 136 of that judgment, and the last part of it, where the court said, "But the courts also have a role to determine objectively and impartially whether Parliament's choice falls within the limiting framework of the Constitution. The courts are no more permitted to abdicate their responsibility than is Parliament. To carry judicial deference to the point of accepting Parliament's view simply on the basis that the problem is serious and the solution difficult would be to diminish the role of the courts in the constitutional process and to weaken the structure of rights upon which our Constitution and our nation is founded." I ask you to please set that constitutional